Welcome to Off the Record, a legal podcast.
Hello and welcome back to Off the Record with Rhett Burney. Rhett is a family law and estate planning attorney based in Greenville County, South Carolina, where he's helped families navigate divorce, custody, and future planning matters for almost 30 years. We also have the pleasure of having a special guest, attorney Bill Finn. My name is Kevin Rosenquist. Today we're talking about adoption in South Carolina. They're going to walk us through how the process works, what families can expect, and why the right preparation matters from the start. Rhett, Bill, great to see you guys again.
Hey, Kevin.
Great to see you, Kevin.
So to start, could you explain the different processes for adoption in South Carolina?
Oh, yeah. You're going to start with that, huh, Kevin? So, adoption, several things can happen. It could be a situation where a child, a parent decides they can't raise the child and they put the child up for adoption. They go through an agency and a parent can adopt through that process. There's also those times where a child is brought into, we'll say, child protective services and the parents are not fit and it would be better for the child to be adopted, and they follow that process and go down that line to have the child adopted. Or it may be that, grandparents, for instance, may want to adopt their grandchild because the parents of that child are not capable of watching the child, taking care of the child. Could be a situation where you have two parents, but only one parent's involved in that child's life, while the other parent hasn't visited for a period of time, hasn't paid any child support or provided any support for a period of time. And that opens up the door for a termination of parental rights case and then leading to an adoption. So several different ways to get to the adoption process, but at the end of the time, at the end, the results are the same. That child is now seen by the courts as the legal child of the parent or parents who have adopted that child.
In your experience, is there anything that surprises families once the process begins? Like, do they think things are going to go a certain way when in fact they don't? That's not how it works.
We see sometimes parents think, okay, well, I want to do an adoption. It's as easy as getting in front of the court and saying, I want to adopt this person. And that's really not the case, especially when it's a child adoption. You have to get a guardian ad litem appointed. That's someone who looks out for the best interests of the child. They're almost like an attorney for the child. And they present a report to the court about what they believe is in that child's best interest and whether the adoption is appropriate or not. So that's a step that people often don't realize is going to come into play. Another wrinkle is a name change. Sometimes when you're doing an adoption, you also want a name change. And there's different standards and different things you have to prove to the court in order to get a name change. And when it comes to a child, there's certain factors that have to be met that the guardian ad litem investigates as well, but that you have to show to the court that you meet those factors in order to effectuate the name change. And if it is an adult adoption with a name change, you have to show other factors. You have to show that you're not avoiding any child support obligation or any bankruptcy proceedings and things like that. So there are different wrinkles to adoptions depending on the case that people don't always realize are there. It's not as simple as just saying, well, I want to adopt them and be responsible for them.
Yeah, and to add to that, Kevin, remember when you're adopting a child, there is either one or two other parents of that child that have an opportunity to come speak to the court, and they may not want you to adopt their child. Mm-hmm. So then those become a contested adoption, and that always adds a new wrinkle in the case. And I can't tell you how many times we've had those cases where the facts are great. The only problem is it's not the facts of the case that make it difficult. Sometimes it's the personalities involved. So when we have those types of cases, let's say where the one or both parents are drug addicts, they have an addiction problem. Well, those are not the easiest people to reason with. They think they're great parents and they're really not. But, the court has, those legal things that we have to step through in order to terminate those parents' parental rights in order for our client to adopt them. So, just wanting to adopt a child is great, but doing it sometimes can be difficult depending upon the facts of the case.
You mentioned the best interest of the child. Of course, we've got the rights of the biological parents as well. How do the courts balance that? I mean, I suppose it's got to be a pretty extreme situation to pull rights from biological parents, right?
It is. And there's statutory requirements in order to terminate someone's parental rights. A lot of that is failure to exercise any visitation with the child for an extended period of time, or failure to support the child in any way, financially particularly. But there's different standards that can be met, different grounds for a termination of parental rights. You still have to show that to the court, and the court still has to grant that. It is not just an end-all, be-all. They haven't seen the kid and we're going to get their parental rights terminated. You have to show that to the court, and it has to be a willful failure to exercise a visitation or a willful failure to support. Sometimes, if somebody's incarcerated or deployed or something, they might meet those standards that they haven't seen their child in long enough time, but it's not willful. There's a reason behind it. So there are nuances to those grounds that you have to take into account when you're trying to terminate someone's parental rights and do a subsequent adoption.
And it's not just because the person who wants to adopt can provide a better life for that child, because there are people out there that can provide probably a better life than I could for my children, right?
Yeah,
but
sure.
but that's not the standard. The standard is the clear and convincing evidence. Is it in the best interest of the child? Not that they can provide a better life, but is it in the best interest? And the courts take it very, very seriously when they terminate a parent's parental rights that then frees the child up to be adopted. So we have statutory language that we have to meet in order for that parent's parental rights to be adopted. Just like Bill said, it's usually lack of visitation, lack of pain support. It can also be, they can have mental issues, can have some certain types of addictions and so forth. But for the most part, if the person is not consenting, because you can consent for your child to be adopted, but if they're not consenting, usually the most common are some type of addiction or failure to support or failure to visit the child.
Mm-hmm. So walk me through the process. If someone wants to start the process of adopting a child, how does that work?
First, you have to have a child to adopt, right?
Okay, hang on. I'm going to write this down. Number one, have a child.
And you have to want to. And I'm adopted. I happen to be an adopted child, and I think it's probably one of the greatest things someone can do for a little baby, right, is to adopt them and provide them a better life that they wouldn't have otherwise had. But you say you find a child who cannot be cared for, right, and their parents are either non-existent or just completely absent. And so once you have that, that child may have already been put in your custody because of a familial relationship, or the Department of Social Services, Child Protective Services may have placed that child in your care. And those are a little bit different than an adoption agency finding a child where the parents are consenting for you to adopt the child. That's a completely different process. So once you find the child that needs to be adopted, you bring a lawsuit and you're naming the parents and you're asking that their parental rights be terminated, and then freeing that child up for adoption.
What about when it comes to stepchildren? If someone wants to adopt a stepchild, is that an easier process? Is it a similar process?
It depends on the nuance of the case and the facts of the case, but generally it can be easier. They're already involved in the child's life and they already have an attachment to the child most of the time. So that's going for them on that side, but you still have to terminate that biological parent's parental rights. And depending on that situation, whether that parent's involved, whether they're struggling, like Rhett said, with an addiction, whether they failed to financially support, and whether they're contesting it or not, that can make it more difficult. Generally, step-parent adoptions are kind of foreseen. You can gauge the situation based on the facts of the case, as if this is kind of going to be a successful action or not, or if it's going to be a contested action or not. If there's a step-parent already involved, the court is more likely to terminate someone's parental rights if you have the grounds, because there is another parent willing to step in. The court is hesitant to leave a child with only one parent that is responsible for them. It's not to say it's impossible, but it's a harder process. So when you have a step parent that's willing to step in, and especially if it's an uncontested adoption, it generally does go smoother.
What kind of timelines on average are families looking at here from start to finish?
That's the age-old question, Kevin. We always get asked how long and how much, and always fact specific. If both parents are dead, that makes it easier. If you have a parent who has just disappeared, and you have a step parent adoption, that makes it easier. and we can usually get those done within three to 6 to 9 months.
Mhm.
But when you have some parent that is just contesting it, you have to go through all the steps. And in South Carolina, that means you have to go through mediation before this can be done. I have a case right now that the termination of parental rights and the adoption, I'm pretty confident will go through because the other parent has just had nothing to do with the child. But guess what? They won't agree to it. And they're just trying to make it very difficult for whatever reason. Sometimes just pride. They don't want to be that parent who lost the rights to their child. And that just drags the case out. And those types of cases are going to take a year or more to be resolved. And if you have the cases where a child is coming in through the Department of Social Services, that could take several years because there's so many different hearings and hoops that have to be jumped through. So there's no definitive answer. Is this only going to take 30 days or 60 days or 90 days? It's all fact specific. But I think if someone's looking to adopt a child, and it's not going through Child Protective Services or DSS, it's probably going to take 6 to 9 months, and if it's contested, a year in order for it to be finished.
Yeah, absolutely.
Yeah, it can be it can be a grueling process in a lot of situations. My wife and I looked into it years ago, and we were surprised by how difficult it actually is, because you're like, man, kids need parents, and this seems difficult. Are the protections in place overdone, or do you think that the process is good?
I think it's a good process. There's a very strong interest in protecting someone's parental rights, and that's a good thing because we want kids to have relationships with their parents, and that's why the court is so hesitant to terminate parental rights. But all these hoops and things you have to jump through, it really ensures that the parties wanting to adopt really want that. And you have to testify at the hearing that you understand you are responsible for this child with both any kind of support, financially, emotionally, anything, and you're responsible for their well-being. And it also means that, say it's a step parent adopting and down the road they get into, a divorce action with the biological parent. Well, if the step parent is adopted, they have the same legal rights to that child as the biological parent.
That's a good point.
And the court does take it very seriously, and they're going to want to make sure that everybody understands what they are signing up for and what they're responsible for. So I think the protections and all the precautions in there are a good thing in the end. It can make some cases harder and longer, but it protects the integrity of the system and the integrity of the adoption process.
Yeah, and Bill brought up a good point. If you are adopting a stepchild, you may go through a divorce later on and have to pay child support to a child that's not even biologically yours.
Mm-hmm.
On the flip side of that, you can allow your new spouse adopt your child, and you could lose custody of your biological child to that now ex-spouse because they're deemed to be the better parent. So, there's some conundrums in there possibly. So it's a big deal. And I think that's just one of the reasons why we have these safeguards in place and we have the laws in place, because there are big consequences that follow the termination of parental rights of a child and the adoption of a child. So, some people think that it takes too long, doesn't make enough sense. I get it, but it's really to protect everybody, because I think when you terminate the parental rights of a parent, that's kind of the nuclear bomb of family court cases.
Yeah, I agree.
Yeah, so you've got to make sure, or the courts need to make sure that it is, it's done properly.
Absolutely. That's a really good way of putting it too. That is the nuclear option for sure. Is there any difference in the process or the difficulty or the time or anything when you're, between adopting an infant and adopting a 4-year-old to a 8-year-old to a 15-year-old or something like that?
There can be differences, especially if you want a name change done as well. Some of those name change factors can relate to the child's identification to their current name and how they perceive themselves. So the older they get and the longer they're attached to that name, it can make things a little more complicated, make it a little harder to get that name change. And as the older they get, the court is more likely to consider, what the situation has been throughout their whole life. When you get to become an adult adoption, it's a little easier because everybody's adults in those points. But as a child, it is, depending on the age, it can be a little bit of a harder process. An infant adoption, they're not attached to their name. They're not really cognizant of their worldly situation. So sometimes that can be easier, but it still depends on the facts of the biological parents and the facts of the surrounding aspects of the case.
And if a child gets older, they have more input into whether they want the adoption to occur as well. Because statutorily, once they get to be a certain age, the court may want them in the courtroom, or they may want that child to, say, sign off on the adoption. So it is much easier, I think, from a practical standpoint, to adopt an infant or a smaller child. But again, the facts are going to dictate, what the other parent, the parents whose parental rights are being terminated, what they want to do. But there's some extra steps in there as children get older.
Rhett, I'm curious, you mentioned that you were adopted yourself. Does that change your sort of passion for this area of family law?
I see the goodness in it, right? I don't know, that doesn't necessarily make me more passionate about it. But when I sit back and I see, probably on the flip side, when I see these cases where people are abusing children, and I know that there are parents out there or people out there who can't have children, it seems to be, a perfect matchup. If you're going to abuse these children, you don't need them, shouldn't want them, and these people do. Why is the process not easier? And I think that people, pregnant women and men who've gotten a woman pregnant, I think they forget that adoption is an option out there. And there's some wonderful people who can provide and want to provide a better life. And I think we need to do a better job in reminding people that, hey, adoption is a great thing. It is filling a need for everybody. And I think that people kind of have a knee-jerk reaction to that sometimes and just forget that there are people out there who cannot have children, who want them badly, and adoption is their only option. And there are other people who can have children but still want more, and they want to help people and want to adopt. So I think people need to be more cognizant of the fact that adoption is an option and is out there. And, a lot of people who want children and can't have them.
And the overriding standard the court's going to look at is the best interest of the child. So I think that's something people need to keep in mind as well. It's, there's the pride aspect of things, and there's the, ability to care aspect of things. But what is truly in the best interest of this child is something I think people should be cognizant of.
Yeah, absolutely. Well, great stuff as always. All right, that's it for today's episode of Off the Record. If you'd like to learn more about attorney Rhett Burney and special guest attorney Bill Finn and their work serving families across upstate South Carolina, visit rhettburney.com. Thanks for listening. Don't forget to leave us a review, subscribe to our channel. We very much appreciate it. Rhett, Bill, really enjoyed the conversation. Thanks so much.
Right. Take care, Kevin.
Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.